1.
This Honorable Court of Criminal Appeals of Tennessee is now in session.
Thank you, Mr. Clerk. This is a continuation of the February docket for the Western Section of the Court of Criminal Appeals. The panel today is Judge Camille McMullen from Memphis, Judge Ross Dyer from Memphis. I am Kelly Thomas from Maryville. 20 minutes aside, as usual. If the appellant wants to reserve some rebuttal time, please tell me when you start your argument. I'll give you 2-minute warnings as appropriate. We appreciate the work of our Supreme Court clerk, Mr. Hibner, and our folks from the AOC, Mr. Nick Morgan and Barbara Peck. There's a lot that goes on to make this happen, and we appreciate what they've done to make it happen for us. So if you'll call the next case, please.
State of Tennessee versus Ivin Lee Robinson.
On behalf of the appellant.
Good morning, Your Honor. I'm Alex Camp. I represent Mr. Robinson.
All right, sir.
Okay. May it please the court, I would like to at this time request 5 minutes for rebuttal.
Very well.
Thank you. Your Honors, briefly, Mr. Robinson, on or about August 6, 2012, was indicted on 3 counts for a first-degree murder, a felony murder, and as well as an especially aggravated robbery. As a trial strategy, on the day of the trial, Mr. Robinson entered a plea of guilty on the especially aggravated robbery and trial pursued with the murder charge. I have reasoned 3 issues that I find relevant for this case here today, 2 of which I will elaborate in great detail, and the third one as more or less just an issue of itself that maybe doesn't stretch quite as the importance of the primary issues. Those primary issues, Your Honors, are that of the causation and the sufficiency of the evidence of the murder charge itself, as well as the issue concerning the lesser includeds that were read to the jury at the time of the jury instruction phase during the trial. Now, briefly to go into the facts of this case, Your Honors, Mr. Robinson was a gentleman from Humboldt, and he and a group of individuals were essentially charged with going into a gentleman's home. That gentleman's name was Mr. Sims. Mr. Sims was a man in his 80s that apparently lived by himself, and Mr. Robinson and them went inside the home, and the testimony and proof showed ultimately that Mr. Sims was shot. Mr. Robinson was accused of having done the shooting, and that took place on or about December 27th of 2010. Now, Mr. Sims did not actually die until February 16th, 2011. And I'd like to make a point of clarification.
Mr. Camp?
Yes.
Mr. Camp? Yes, I was getting ready. Hopefully you will make a clarification because I note in your brief, which upon reading was somewhat alarming. I assume it was a typo, but in a causation case like this, I need for you to pay close attention to those factors. Go ahead.
You're right, Your Honor, and this is my chance to redeem myself. I don't know what I was thinking. I guess February 16th, 2016, I had 16 on the brain. I don't really have an excuse, but it was 11. I go on to elaborate. I did announce roughly 2 months after is when he ultimately expired. I just want to make that clear for the record. My intention obviously wasn't to mislead anyone, but he did pass away about 2 months after. So what had taken place is initially when the gentleman entered the hospital to be treated for his wounds, he stayed there for a few days. Well, they actually identified several chronic illnesses that were actually diagnosed as more or less approximate cause of his entry to the hospital from the gunshot wounds. I go into great detail about all those illnesses in my brief, and I don't mean to belabor the point. Half the words I really can't even pronounce, but I gathered from it that he was obviously riddled with a lot of issues. Some of the ones that were particularly alarming to me were that of COPD, congestive heart failure, and renal failure. And ultimately, he passed away from a stroke. That was the ruling cause of death by Dr. LaBoy, who was the medical examiner that conducted the autopsy in this case. Nevertheless, Mr. Sims was released from the hospital and then readmitted for some health issues shortly thereafter, and then released again. And then when he was released the first time, he was released with a description by the hospital here at Jackson General in this city as healing from his wounds. Okay, and so there were positive indications from Mr. Sims's recovery that we were given, and I'll tell you why that's important as I dive now into the issue of causation. I go into this point, Your Honors, and I think this is very critical, in that there was a sidebar conducted at the bench with Judge Peoples and the attorneys that took place during the trial, where they ultimately determined about the jury cause of death instruction. That's very critical, obviously, in establishing a homicide case, especially one unique like this situation where Mr. Sims didn't perish when we would think traditionally the decedent should perish as a victim of a gunshot wound. That being said, the court read, as I state here, but before the defendant can be convicted of any degree of homicide, the state must have proven beyond a reasonable doubt that the death of the deceased was proximately caused by the criminal conduct of the defendant. The proximate cause of a death is that cause which in natural and continuous sequence, unbroken by any independent intervening cause, produces the death and without which the death would not have occurred.
But didn't Dr. LeBoy testify at length that the victim would not have passed away but for the gunshot wounds? I mean, this was the issue. He was cross-examined ad nauseum regarding each of the conditions that were borne out in the medical history of the victim in this case.
Your Honor, he did testify to that effect.
Extensively.
I will add as well, he gave concessions related to the issues of the victim's natural state as well.
Sure, they were in his medical records.
Correct. And ultimately, the fate, I would reason, as he couched it, was exacerbated by his natural condition. To me, lacks that sufficient causation in establishing a nexus between the gunshot wound and the death, and almost amounts to somewhat speculative reasoning based on how much time took place in between, as well as the victim's condition at the time he was shot. And ultimately,
I'm kind of law school 101, I use the same phraseology in the last case, but I mean, one of the first things we learn is we take our victims as we find them. So you have the hypothetical of, the man with the heart condition, who someone comes up and tries to carjack him. It causes him to either have a stroke or have a heart attack. Well, he had an underlying heart condition, which probably made him more susceptible to that stroke or that heart attack, but it's the defendant's actions that triggered it. And I think what Judge McMullen is asking, and what the doctor testified to, was, but for your client's actions triggering these underlying conditions, making them worse, he wouldn't have died 2 months after the incident.
I suppose, Your Honor, what's misleading about that from our position is that the hospital records indicated to the contrary upon his release. I mean, there's verbatim record that says the victim is on track to recover from the gunshot wounds. And to the contrary, his conditions that were discovered were so chronic, and he was so ill from all these other illnesses that I cited in my brief, that it's a stretch to a sense that suggests speculation that's concerning when you're talking about absolute causation, because that's what's demanded.
If a doctor said, the victim is recovering from a gunshot wound, but he has all these underlying conditions that somehow, even though I may say on Monday he's recovering from the wound, if his underlying conditions, which your client worsened, so to speak, because of the gunshot wound, keep him from healing as the doctor might have thought, and he dies by Friday, can't we say that your client is the cause?
It's an interesting point, and I don't know when or how long you can hold on to a wound to hold that person responsible for that wound. 2 months, obviously, is a.
Well, that's what we have. That's what we have medical experts for, isn't it? Though.
You're right, and his reasoning, as it's suggesting that it exacerbated the condition, doesn't suggest to me, if I'm taking it in its literal sense, that it killed him. It just exacerbated means worsened, but he died from another condition.
Did you put on expert medical testimony in this case?
I did not personally. I didn't try the case, Your Honor. I'm just handling it at the direct appeal phase. But
I mean, was there expert?
Expert was not.
Whether you tried it or not, we don't have any. You're relying on experts that would say what you're saying is speculative, but there was an expert who testified. So I'm trying to figure out what you're saying is wrong in this case.
Basically reaching the conclusion that an exacerbated condition equals a homicide. In other words, the man died from something else, but they're saying that the gunshot wound worsened his condition to make him die of that. So it's almost as if he died of something else. He didn't die of a gunshot wound. He died of a condition that was exacerbated by his gunshot wound. And the causal connection is not, it's our argument is not sufficient evidence, because all his other conditions exacerbated his condition as well. Right. In other words, all of his chronic conditions were testified by Dr. LeBoy as serious issues, natural issues. It's in his statement.
Mm-hmm.
Now, I would move on, if there's no more questions related to that issue, to the next issue of the lesser included offenses. Tennessee Code Annotated 40-18-110 essentially handles the lesser included offenses. And it indicates to us, and we learned from during the trial transcript, that the jury and the defendant mainly is entitled to all lesser included offenses if it's legally sufficient to support the conviction. And so as I go into my analysis, my client was convicted on lesser includeds. He was convicted of second-degree murder, which is a lesser included of his original indicted charge. On the premeditated side of the spectrum, they went all the way down to simple assault in a reading to the jury. However, on the felony murder side of the spectrum, the judge stopped short. I cite case law in my brief, Your Honors, that seemingly suggests that that was in error. And the reason why is because second-degree murder is not where he should have stopped. It should have gone to reckless and on to criminally negligent homicide for the jury to consider, but my client was deprived that reading, and the jury didn't hear that for consideration. And I'd argue that not telling the full story and not providing full consideration deprives my client of a due process that he's entitled to from those readings, from that statute, from this case law. The policy that seems behind the reading and why my clients do this deference is the situation that the only difference between those crimes, the second, reckless and criminally negligent, are its seriousness and its punishment. Okay, and naturally you fail to read the less serious and the lower punishment threshold crimes. That obviously is going to bode against my client's favor. We feel that was done in error, that he was due that right for that reading. We think that in addition, the facts would support that reading. Matter of fact, Mr. Robinson's actions could have been deemed so reckless that it could have amounted to a reckless homicide. But that wasn't read for him in both considerations. That could have been confusing to the jury. And you see that they stopped at a second-degree murder that was ultimately merged, but it's impossible to tell on the back end in hindsight what the reasoning was. And it would have been more complete and fairer to my client had we just given them the options that, pursuant to case law, he seemingly deserved to have read for them. I would close that issue, but we're left to guess, and we're left to basically realized that my client didn't get his fair shake in those readings that he was due and owed. And so we'd say that and suggest that that was done in error and a failure to instruct the jury through a reading of those necessary lesser includeds. Your Honor, my last issue is dealing with the sentencing phase. And ultimately, what it boils down to is the trial court judge sentenced him to consecutive 40-year sentences. We would suggest that that's not the least severe measure necessary to achieve the purposes of sentencing and their impositions. We would ask that a more specific reasoning needed to have been provided to justify that sentencing. And so we think that in itself, that sentencing is beyond necessary to establish just sentencing for my client. If the court doesn't have any questions to follow up, those are the issues that Mr. Robinson would ask you all to consider here today. Thank you.
Thank you. On behalf of the appellee.
Thank you, Your Honors. Jonathan Wardle for the state of Tennessee. I'd like to start with a thank you and acknowledgement. It's amazing to me that we can do this as we're doing it, and I appreciate the effort it takes on behalf of Your Honors, the judges, Mr. Hibner, the various staff and clerks involved. So I really appreciate this, that we can move forward. I guess I'll just hit the issues in the order that Mr. Camp did. As to causation, I like Judge Dyer's Law School 101 analogy. It brings to mind cases that I have long since forgotten. Falls Graph is a case some may remember. The eggshell school rule is another. The fact is, the jury had all of the evidence before it, and that's kind of where it ends. The jury had the evidence, and it made its decision. The medical examiner testified, yes, he had these underlying conditions. And the medical examiner testified that the gunshot wounds exacerbated those, made them worse. He testified that the gunshot wounds actually added additional complications. The medical records did show that he went home for 3 days after being in the hospital for very nearly a month, went home for 3 days, had a stroke, went back and died a while later. I think it was a week or two later after he went back to the hospital. And Dr. Lavoie explained all of that to the jury. Explained exactly how this could have happened and opined, in his opinion, which is the reason you have expert testimony, is to get their opinion. And his opinion was that the gunshot wounds were the cause of the death, and he explained how that happened. With that testimony, the evidence was sufficient to sustain the jury's conviction. And I understand all of Mr. Camp's other arguments, but again, the fact is that was for the jury to decide, and the jury made its decision. So unless there are further questions on that issue. All right. I'll move on to the lesser included instructions. I like what Mr. Camp said. It's impossible to tell on the back end what the reasoning was for the jury. This is a case where the verdicts are both inconsistent and consistent. Really, in the most extreme, 2 second-degree murder convictions for the exact same conduct is about as consistent as you can get. And at the same time, it's hard to reconcile the jury finding that he caused the victim's death, caused Mr. Sims' death, and at the same time was not guilty of felony murder, where Mr. Robinson admitted that he shot the victim in the course of an aggravated robbery, which is the paradigmatic felony murder. So it is, we can see an inconsistency, but this is what we allow the juries to do, and for good reason. We don't try to parse what the jury is doing. For the jury instruction issue, the court instructed the jury on what they needed to know. On premeditated murder, mens rea was an issue, and so the court instructed all the way down. On the felony murder, the mens rea was not an issue, and the court is only required to instruct the lesser includeds that apply to a particular fact of the case. And there are several cases in Tennessee that hold that the trial court does not need to instruct on cases, or instruct on lesser included offenses when the facts do not support them. In this case, you had an all or nothing with respect to felony murder. Either he caused the death or he didn't. If he didn't cause the death, then it's a complete acquittal on the felony murder. If he did cause the death, then it's felony murder. All right, so the judge didn't need to instruct on all of those. We would submit that it is not error. But to the extent there was any error, it is absolutely harmless because what I said at the beginning, completely consistent with the premeditated murder charge. The jury had all the instructions all the way down and chose second-degree murder, and then chose second-degree murder for the exact same murder with respect to the felony murder charge.
Which, in the sequential nature of how they were charged, was premeditated charged first with all the lessers and then felony as in count 2 and then just the one lesser, or was it vice versa?
No, Your Honor, it was
difference.
So that doesn't make a difference is the harder question to answer. The first question, it was charged. Count 1 was the premeditated, and they were charged on that and all the lessers. Count 2 was the felony murder, and they were only given second degree as a lesser of that. And I would submit, by the way, Your Honors, that second degree murder charge wasn't necessarily warranted, but they were given it, they took it. And I suppose that was to be consistent with the premeditated murder charge. Now, as to whether it made a difference, well, you're supposed to go in order, both in order of counts and in order of higher to lesser. So in theory, yes. Then again, the jury has read all the instructions before they decide any verdict. So does it make a difference? Again, we go back into, we can't really get into the jurors' minds. And this court has drawn a hard circle, and the Tennessee Supreme Court has drawn a hard circle around that. We just don't try to parse the jurors' reasoning as long as the evidence to support it and as long as they're instructed correctly.
Yeah, and I don't disagree with you that we can't really go back and try to figure out what they were thinking. My point, though, was what it did maybe lend some credence to the defendant's argument. If you charge felony murder first, they came back with second degree, and then count 2 is premeditated, and they stopped at second degree. Were they was the jury actually trying to make consistent verdicts? Who knows? I mean, just food for thought, I guess, as I'm kind of thinking through how that happened.
No, and I can see that, Your Honor, but my recollection is that premeditated murder was charged first, and so that line of reasoning doesn't apply.
Okay.
Unless there are further questions on the lesser included instructions, again, the state's position is the lesser included weren't warranted, but even if they were warranted, they're absolutely harmless here. As to consecutive sentences, again, Mr. Camp said more specific reasoning was needed. The trial court did what it needed to do. It articulated the necessary finding, and it found 2 things: extensive criminal record, dangerous offender. Either one of those is sufficient to uphold consecutive sentencing. And Mr. Mr. Robinson had an extensive criminal record. I believe he had 22 convictions on his record. He had, I think it was 8 prior felony convictions. After shooting Mr. Sims, he went out and committed another aggravated robbery. He has an extensive record. So there's absolutely reason for consecutive sentencing, or at least to affirm the trial court there. As for the dangerous offender, I mentioned in my brief that the trial court did not explicitly make the Wilkerson findings, but there's certainly enough for this court to find them if it needs to, but it doesn't need to because the extensive criminal record is enough to affirm the consecutive sentencing. So unless there are further questions on the sentencing issues, I would just ask that this court affirm the jury's verdict and the trial court sentence. Thank you, Your Honors.
Thank you. You have 5 minutes for rebuttal if you wish.
Thank you, Your Honor. Just to point on a issue that was raised by my opposing counsel, I want to make it clear my understanding of the law, and I'm citing the State versus Page case, which is the Tennessee Supreme Court case that I found persuasive as it applies to the lesser included. It seemingly was suggested that my client was almost, I don't know if I want to use the word lucky, but just it was, at least he got that bone thrown at him, that he got the reading of the second degree murder in the felony murder lesser included instruction. I want to make it clear our position. It's not a question of if, it's not a question of maybe, it's a question of, it's an issue of must. My client has an absolute right to every single offense that is applicable in this case. And it can be reasoned that every single offense, especially with this issue of causation can be interpreted and inferred that there was recklessness involved in this situation, and perhaps even a notion of negligence. And ultimately, my client wasn't read that instruction when he should have been read it. That instruction's relevant to this case. It's applicable to include the lesser includeds, and he was deprived that right. For whatever analysis was taken, it was erroneous, because the reality is my client has a right.
The state's argument is, if I understand it correctly, is that the state's proceeding on two theories. One being the premeditated, which clearly his intent is at issue. And therefore, the trial court charged all the way down. What was his intent? Well, it could have just been a knowing killing. It could have just been a reckless. He just could have been negligent. Okay. But when we got to felony murder, the only question was, did your client die during the perpetration of a felony? And so his intent, whether it was reckless or not, whether it was negligent or not, doesn't necessarily apply. And so he got the benefit of it on the first degree murder premeditated charge, but he didn't necessarily need it on the felony murder charge, because intent is not an issue on that theory.
I see what you're saying, Your Honor. The problem is if they're not read, when they're read, sitting and listening to all those instructions, we don't know if they stop one place, do they automatically stop at the other place? Or if they're read that, oh, there's lesser options on this side of the spectrum as well, how they reason that spectrum. I can only work with the fact that it wasn't read in full where it should have been. And that's problematic because it doesn't give us a complete picture. This issue isn't presented had it been read to my client's right and deference. And that in and of itself is an issue that just needs to be brought to light and reviewed and ruled upon is our position, because we feel that he was wrong there, Judge. I don't know really what else to say other than I can't predict the mind of the jury. And I know we've made that mention, but if they're not read the complete story on everything, then it begs the question about whether or not their verdict was fully comprehended.
Let me ask the question a different way then.
Sure.
If my only theory at trial is that this is a felony murder, and I have the facts that I have here, how does that constitute? How did you prove that it could be a reckless homicide or a negligent homicide? What facts that were presented at trial would allow a jury to come back with a reckless or negligent homicide? If my only theory is that it is the result of a felony murder,
I see your question. My line of defense is primarily the causation. I don't believe that the murder took place. It was an exacerbated issue, that the man was shot and his conditions worsened. But it's a position where we disagree that there was a murder in and of itself that took place. It was essentially pled guilty to especially aggravated robbery, but that would be our defense on it, if that answers your question.
Okay.
Thank you. I yield my time.
Thank you. Thank you for your arguments.
Thank you.
This honorable court is now in recess until 11 a.m.